In January 2018, Mrs. A married woman on her 6th month of pregnancy, was crossing a street when she was suddenly hit by a car being recklessly driven by Mr. X. As a result, Mrs. A sustained serious injuries and further suffered an unintentional abortion. Mrs. A was hospitalized for 2 months, during which she incurred $400,000 in medical fees. Her expenses were all duly substantiated by official receipts. During the 2-month period of her confinement, she was unable to report for work and earn any salary, which was established at the rate of $50,000 per month. Mrs. A then filed a civil case for damages against Mr. X. May Mrs. A claim damages on behalf of her unborn baby? Explain. No, Mrs. A cannot claim damages on behalf of her unborn baby, since an action for pecuniary damages on account of personal injury or death pertains primarily to the one injured. It is easy to see that if no action for such damages could be instituted on behalf of the unborn child on account of the injuries it received, no such right of action could derivatively accrue to its parents or heirs. In fact, even if a cause of action did accrue on behalf of the unborn child, the same was extinguished by its prenatal death, since no transmission to anyone can take place from one that lacked juridical personality or juridical capacity as distinguished from capacity to act. It is no answer to invoke the provisional personality of a conceived child, conceptus pro nato habetur, under Article 40 of the Civil Code, because that same article expressly limits such provisional personality by imposing the condition that the child should be subsequently born alive, provided it be born later with the conditions specified in the following article. Gallus versus C.A. Gr. L. 16439, 1961. In the present case, since the unborn child lacked the needed juridical personality due to the unintentional abortion, Mrs. A cannot claim damages on behalf of her unborn baby. Question number 2. H and W were married in 1990. H, being a member of the Armed Forces of the Philippines, was deployed to a rebel-infested area in 1992. Since then, W has not heard from her husband, H. One day, the AFP informed W that H had been declared missing since 1995. In consequence, W diligently pursued all available means to ascertain her husband's whereabouts, but to no avail. Firmly believing that H had already died, W filed a claim before the AFP in 2008 for the death benefits of the missing serviceman. However, the AFP, despite being cognizant of H's status, would not act on the claim, contending that H could not be presumed dead unless a judicial declaration to this effect is issued by the proper court. In what instances is a judicial declaration of presumptive death necessary? In this case, is the contention of the AFP correct? Explain. A judicial declaration of presumptive death is necessary under Article 41 of the Family Code for the purpose of contracting a valid subsequent marriage. No, the contention of the AFP is not correct. Here, W was not seeking the declaration of the presumptive death as a prerequisite for remarriage, but to claim the death benefits due to the missing serviceman. W was relying on the presumption of death under either Article 390 or Article 391 of the Civil Code as the basis of her petition. A petition for declaration of presumptive death based on the Civil Code is not allowed. Articles 390 and 391 of the Civil Code merely express rules of evidence. Thus, an action brought exclusively to declare a person presumptively dead under either of the said articles actually presents
no actual controversy that a court could decide. In such action, there would be no actual rights to be enforced, no wrong to be remedied, nor any status to be established. A court action to declare a person presumptively dead under Articles 390 and 391 would be unnecessary, as the presumption in the said articles is already established by law. Tadeo Matias versus Republic. Number 3. Mr. Reyes is legally married to Mrs. Reyes. During the subsistence of their marriage, Mr. Reyes cohabited with another woman, Miss Cruz, out of Mr. Reyes and Miss Cruz's illicit relationship. A child named C was born. In C's birth certificate, Cruz appears as the child's surname, although Mr. Reyes expressly acknowledged C as his child. In 2018, Mr. Reyes and Mrs. Cruz, or Miss Cruz, ended their relationship. Mr. Reyes thereafter lodged a petition in court for parental custody and change or correction of C's surname in the child's birth certificate from Cruz to Reyes. At that time, C was only 10 years old. Letter A. Should Mr. Reyes be granted custody of C? Explain. Letter B. Can Mr. Reyes validly compel the change or correction of C's surname from Cruz to Reyes? Letter A. No. Mr. Reyes cannot be granted custody of C. C is an illegitimate child, and parental authority over illegitimate children is lodged by Article 176 of the Family Code on the mother. Hence, Mr. Reyes' prayer has no legal mooring. Since parental authority is given to the mother, then custody over the minor illegitimate child also goes to the mother, unless she is shown to be unfit. Guande versus Antonio, February 18, 2014. Letter B. No. Mr. Reyes cannot validly compel the change or correction of C's surname from Cruz to Reyes. The general rule is that an illegitimate child shall use the surname of his or her mother. The exception provided by RA 9255, an act allowing illegitimate children to use the surname of their father, is in case his or her filiation is expressly recognized by the father through the record of birth appearing in the civil register, or when an admission in a public document or private handwritten instrument is made by the father. In such a situation, the illegitimate child may use the surname of the father. Article 176 of the Family Code gives illegitimate children the right to decide if they want to use the surname of their father or not. It is not the father or the mother who is granted by law the right to dictate the surname of their illegitimate children. The use of the word may in the provision readily shows that an acknowledged illegitimate child is under no compulsion to use the surname of his illegitimate father. The word may is permissive and operates to confer discretion upon the illegitimate children. Grande versus Antonio. Question number 4. F, a Filipina, married J, a Japanese, in the Philippines. After 3 years, they had a falling out and thus separated. Soon after, F initiated a divorce petition in Japan, which was not opposed by J, because under Japanese law, a grant of divorce will capacitate him to remarry. F's divorce petition was then granted by the Japanese court with finality. May the legal effects of the divorce decree be recognized in the Philippines and consequently capacitate F to remarry here? Yes, the legal effects of the divorce decree may be recognized in the Philippines and consequently capacitate F to remarry here. Foreign divorce decrees obtained to nullify marriages between a family and an alien citizen may already be recognized in this jurisdiction, regardless of who between the spouses initiated the divorce, provided that the party petitioning for the recognition of such foreign divorce decree, presumably the Filipino citizen, must prove the divorce as a fact and demonstrate its conformity to the foreign law allowing it. whether the Filipino spouse initiated the foreign divorce proceeding or not. A favorable decree dissolving the marriage, bond, and incapacitating his or her alien spouse to remarry will have the same result. The Filipino spouse will effectively be without a husband or wife. A Filipino who initiated a foreign divorce proceeding is in the same place and in like circumstance as a Filipino who is at the receiving end of an alien-initiated proceeding. Therefore, Article 26, Number 2 of the Family Code should not make a distinction. In both instances, it is extended as a means to recognize the residual effect of the foreign divorce decree on Filipinos whose marital ties to their alien spouses are severed by operation of the latter's national law. Here, provided F proves the divorce as a fact and demonstrates its conformity to the foreign law allowing it, the legal effects of the decree will be recognized and consequently capacitate her to remarry. Morisono versus Morisono, GR 226013, July 2, 2018. Question number 5. X and Y were in a live-in relationship for the longest time and were already blessed with a child, Z. They finally decided to get married on March 15, 2020. When X's parents found out the news, they were thrilled and thus donated in favor of Z the family heirloom, particularly a gold ring valued at $250,000, which X and Y orally accepted on behalf of their minor child. One day, X and Y got into a serious quarrel, which resulted in them setting aside their marriage plans. A. Is the donation to Z valid? B. Assuming that the donation to Z is valid, may X parents revoke the donation on the ground that the marriage of X with Y did not push through? Suggested answer. Letter A. No. The donation of Z is not valid. Under Article 748 of the Civil Code, the donation of a movable may be made orally or in writing. An oral donation requires the simultaneous delivery of the thing or of the document representing the right donated. If the value of the personal property donated exceeds 5,000 pesos, the donation and the acceptance shall be made in writing. Otherwise, the donation shall be void. In the instant case, the donated gold ring valued at 250,000 was only orally accepted, which does not conform to the formalities required by law. As such, lacking the required written acceptance, the donation in favor of Z is void. Letter B. No. Assuming it is valid, X parents may not revoke the donation on the ground that the marriage of X with Y did not push through. First, the ground cited by X parents is not one among those provided under Article 764 of the Civil Code for failure to comply with conditions, nor Article 765 for ingratitude. Second, while the ground cited is one among those which would allow revocation of a donation propter nuptias, however, here there was no donation propter nuptias. Article 82 of the Family Code provides that donations by reason of marriage are those which are made before its celebration, in the consideration of the same, and in favor of one or both of the future spouses. Article 86 of the same code provides that non-celebration of the marriage is one of the grounds for revocation of the donation by reason of marriage. Here, it is clear that the donation was made in favor of the child and not in favor of one or both of the future spouses. Thus, this does not fall squarely within the contemplation of donation propter nuptias. Hence, not being a donation propter nuptias, it cannot be revoked on the ground of non-celebration of the marriage between X and Y. Question 6. Name at least 2 exclusions from the following property regimes, as enumerated under the Family Code. A. Absolute community of property. B. Conjugal partnership of gains. ACP, or absolute community of property. 1. Property acquired during the marriage by gratuitous title by either spouse. and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property.
Number 2. Property for personal and exclusive use of either spouse. However, jewelry shall form part of the community property. Number 3. Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. Family Code Article 92. Conjugal partnership of gains. Number 1. That which is brought to the marriage as his or her own. Number 2. That which each acquires during the marriage by gratuitous title. Number 3. That which is acquired by right of redemption, by barter, or by exchange with property belonging to only one of the spouses. And 4. That which is purchased with exclusive money of the wife or of the husband. Family Code Article 109. Question 7. Believing that he owned a certain parcel of land and completely unaware of any defect in his title thereto, Mr. A started to build a house thereon. When Mr. P, the real owner of the land, learned of Mr. A's actions, Mr. P immediately demanded Mr. A to leave the premises. However, Mr. A refused to leave and instead asserted that as a builder in good faith, Mr. P is obliged to sell the land to him. A. Is the claim of Mr. A correct? Explain. Letter B. Assuming that Mr. P all the while knew but did not object to Mr. A's construction of the house on his property, may Mr. A compel Mr. P to purchase the said improvement due to Mr. P's bad faith? Explain. Letter A. No, the claim of Mr. A is not correct. Under Article 448 of the Civil Code, when the builder believes that he is the owner of the land, the real owner of the land has two options. 1. He may appropriate the improvements for himself after reimbursing the builder in good faith the necessary and useful expenses under Articles 546 and 548 of the Civil Code, or 2. He may sell the land to the builder in good faith, unless its value is considerably more than that of the improvements, in which case the builder in good faith shall pay reasonable rent. The real owner of the land cannot refuse to exercise either option. It is the owner of the land who is authorized to exercise the option, because his right is older, and because by the principle of accession he is entitled to the ownership of the accessory thing. Spouses de Vera versus Spouses Mayondok. GR 211170, July 3, 2017. In the instant case, Mr. P would need to choose between his options and is not simply obliged to sell the land to Mr. A, as what the latter asserted. B. Yes, Mr. A may compel Mr. P to purchase the said improvement due to Mr. P's bad faith. Under Article 454 of the Civil Code, when the landowner acted in bad faith and the builder proceeded in good faith, the provisions of Article 447 of the Civil Code shall apply. Article 447 provides that owner of the land shall pay their value, and if he acted in bad faith, he shall also be obliged to the reparation of damages. The builder, in the case where the landowner is in bad faith, may remove the improvements even if it may result to injury to such improvements. Thus, if Mr. A does not prefer to the latter, he may compel Mr. P to pay the improvements plus damages because of Mr. P's bad faith. Question number 8. Mr. E leased a piece of land from Mr. F to be used for his sawmill business for a period of 10 years. Consequently, Mr. E placed heavy machineries thereon to be used for his aforementioned business, with the intention of removing them after the expiration of the lease period. Are Mr. E's heavy machineries considered real properties under the Civil Code? Explain. No, Mr. E's heavy machineries are not considered real properties under the Civil Code. Article
415, number 5 of the Civil Code provides that machinery, receptacles, instruments, or implements intended by the owner of the tenement for an industry or works which may be carried on in a building or on a piece of land, and which tend directly to meet the needs of the said industry or works are immovable property. Machinery, which is movable in its nature, only becomes immobilized when placed in a plant by the owner of the property or plant, but not when so placed by a tenant, a usufructuary, or any person having only a temporary right, unless such person acted as the agent of the owner. Here, Mr. E is a mere lessee and not the owner of the property or plant. Thus, the aforementioned heavy machineries are not real properties within the contemplation of Article 415, number 5, Davao Saw Mill Company versus Castillo, GR 40411. Question number 9. Miss U is a usufructuary of a piece of land owned by Mr. L. During the existence of the usufruct, Miss U introduced various useful improvements on the land. Upon termination of the usufruct, Mr. L requested Miss U to remove the said improvements, but Miss U refused, demanding instead that Mr. L reimburse her the value of the same. A. What is a usufruct? B. Is Miss U's demand proper? Letter A. Usufruct is a real right of a temporary nature which authorizes its holder to enjoy all the benefits which results from the normal enjoyment of another's property, with the obligation to return at the designated time, either the same thing or, in special cases, its equivalent. Usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law otherwise provides. Civil Code Article 562. Letter B. No. Misuse demand is not proper. Article 579 of the Civil Code provides that the usufructuary may make on the property held in usufruct such useful improvements or expenses for mere pleasure as he may deem proper, provided he does not alter its form or substance, but he shall have no right to be indemnified therefor. He may, however, remove such improvements, should it be possible to do so without damage to the property. Thus, Miss U does not have a right to demand Miss L to reimburse the useful improvements introduced by her. Question number 10. Village H and Village L are adjoining residential villages in a mountainous portion of Antipolo City, Rizal, with Village L being lower in elevation than Village H. In an effort to beautify Village H, its developer X Incorporated constructed a clubhouse which included an Olympic-sized swimming pool and an artificial lagoon on a portion of land overlooking Village L. During the monsoon season, the continuous heavy rains caused Village H swimming pool and artificial lagoon to overflow, resulting into a massive spillover that damaged various properties in Village L. Aggrieved, the house owners of Village L filed a complaint for damages against X Incorporated. In defense, X Incorporation contended that pursuant to the Civil Code, Village L, as the lower estate, was obliged to receive the waters descending from Village H, the higher estate. Hence, it cannot be held liable for damages. Is X Incorporation's or incorporated position tenable? No. No. X Incorporated's position is untenable. Article 637 of the Civil Code provides that lower estates are obliged to receive the waters, which naturally and without the intervention of man descend from the higher estate, as well as the stones or earth which they carry with them. The owner of the lower estate cannot construct works which will impede this easement. Neither can the owner of the higher estate makes work which will increase the burden. A similar provision is found in the Water Code of the Philippines PD number 1067. In the instant case, the swimming pool and the artificial lagoon constructed by X Incorporated consequently increased the burden, as the continuous heavy rains being collected by these artificial works resulted to massive spillover damaging the properties in Village L, while their foresighted provisions impose a natural easement upon the lower estate to receive the waters, which naturally and without the intervention of man descend from higher estates. However, where the waters which flow from a higher estate are those which are artificially collected in man-made swimming pool and lagoons, any damage occasioned thereby entitles the owner of the lower or servient estate to compensation. Reman Enterprises versus CA, April 6, 2000. Thus, for constructing said artificial works, resulting damage to Village L's properties, X is liable for damages. Question 11. Mr. R is the registered owner of a parcel of land located in Cebu City, covered by Transfer Certificate of Title number 1234, issued in 1955. Since his acquisition of the lot, Mr. R and his family had been in continuous, open, and peaceful possession thereof. Mr. R died in 1980, resulting in the land being transferred in the names of his heirs, like A, B, and C, who became registered owners thereof as per TCT number 5678. During the entire time, said land had never been encumbered or disposed, and that its possession always remained with them. Sometime in 1999, ABC wanted to build a concrete fence around the parcel of land, but they were opposed by Mrs. X, who started claiming ownership over the same property on the strength of a deed of absolute sale purportedly entered into by her with Mr. R during the time that he was still alive. Aggrieved, A, B, and C intend to file a complaint for quieting of title against Mrs. X. Letter A. What are the substantive requisites of the action to prosper, to be obtained in this case? Explain. Within what period should A, B, and C file the complaint for quieting of title? Explain. Letter C. Assuming that B and C are resident abroad, may A, without the knowledge of B and C, file the complaint for quieting of title on behalf of all the heirs? Explain. Letter A. For an action to quiet title to prosper, two indispensable requisites must concur, namely, the plaintiff or complainant has a legal or unequitable title to or interest in the real property subject of the action, and 2. The deed, claim, encumbrance, or preceding claim to be casting cloud on his title must be shown to be in fact invalid or inoperative despite its prima facie appearance of validity of legal efficacy. Legal title denotes registered ownership, while equitable title means beneficial ownership. Heirs of Extremadura versus Extremadura, GR 211065, June 15, 2016. Here, the above requisites are present as A, B, and C have legal title in the subject real property, and the deed of absolute sale allegedly made in favor of Mrs. X cast cloud on the title of the heirs.
B. An action to quiet title to property in the possession of plaintiff is imprescriptible. One who is in actual possession of a piece of land claiming to be owner thereof may wait until his possession is disturbed or his title is attacked before taking steps to vindicate his right. The reason for the rule being that his undisturbed possession gives him a continuing right to seek the aid of a court of equity to ascertain and determine the nature of the adverse claim of a third party and its effects on his own title, which right can be claimed only by one who is in possession. Iglesia ni Cristo versus Ponferrada, October 27, 2006. Letter C. Yes, A, even without the knowledge of B and C, may file a complaint for quieting of title on behalf of all the heirs. A, B, and C, as co-heirs, are co-owners of the subject property. As such, co-owners, each of the heirs may properly bring an action for ejectment, forcible entry and detainer, or any kind of action for the recovery of possession of the subject properties. Thus, a co-owner may bring such an action even without joining all the other co-owners as co-plaintiff, because the suit is deemed to be instituted for the benefit of all. Iglesia ni Cristo versus Ponferrada. Question 12. D, an overseas Filipino worker, was on his way home to the Philippines after working for so many years in the Middle East. He had saved 100,000 pesos in his local savings account, which he intended to use to start up a business in his home country. On his flight home, tragedy struck as a suicide bomber blew off the plane. All the passengers, including D, died. He left behind his widowed mother M, his common-law wife W, who is the mother of his twin sons T and S, and his brother B. He left no will, no debts, no other relatives, and no other properties except the money in his savings account. Who are the heirs entitled to inherit from D, and how much should each receive? Explain. His widowed mother and twin sons are entitled to inherit from D. Article 991 of the Civil Code provides that if legitimate ascendants are left, the illegitimate children shall divide the inheritance with them, taking one half of the estate, whatever be the number of the ascendants or of the illegitimate children. Thus the widowed mother M gets 50,000, while the twin sons T and S shall receive the other half of 25,000 each. The common law wife cannot inherit from him as a compulsory heir, as she is not a legitimate spouse. Question 13. M, single, named his sister N in his will as a devisee over a certain parcel of land that he owned, with the obligation of preserving the land and transferring it, upon N's death, to her illegitimate daughter O, who was then only a year old. Is the condition imposed on N to preserve the land and to transmit it upon her death to O a valid case of Fideicommissary substitution? Explain. Yes, the condition imposed on N to preserve the land and to transmit it upon her death to O is a valid case of Fideicommissary substitution. For there to be a valid Fideicommissary substitution, Article 863 of the Civil Code provides the following requisites. 1. There must be a first heir, fiduciary, primarily called to the enjoyment of the estate. Number 2. There must be a second heir, Fideicommissary, to whom the property is transmitted by the first heir. Number 3. An obligation clearly and expressly imposed by the testator upon such first heir to preserve the estate and to transmit it to the second heir. 4. The first and second heirs must be only 1 degree apart. And 5. Both the first and second heir must be living or at least conceived at the time of the death of the testator. Here, all the above requisites are present, as N, the supposed fiduciary, is obliged to preserve and transmit the property of O, her illegitimate child, who is 1 degree apart from her. Question 14. Prior to his death, H married to W with children X and Y, and Z executed a holographic will entirely written, dated, and signed by him. In his will, H instituted W, X, and Y as his heirs, and consequently made testamentary disposition in their favor. H, however, expressly disinherited Z on the ground that the latter once filed a civil case against him in order to collect a particular sum of money he previously owed Z. A. Was the disinheritance of Z proper? Explain. B. Assuming that the disinheritance of Z was improper, how will it affect the institution of heirs and testamentary disposition made in H's will? Explain. Letter A. No, the disinheritance of Z is not proper. For there to be a valid disinheritance, it must be for a cause expressly stated by law. Article 919, number 2 of the Civil Code provides that children or descendant may be disinherited when a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. The requisites of this ground are: 1. The heir must have accused the testator of a crime. 2. The penalty prescribed by law for such must be 6 years imprisonment or more. And 3. The accusation must have been found groundless. Here, Z filed a case and not a criminal case. It was a civil case. Thus, the above requisites are not present, making the disinheritance not proper. Letter B. Article 918 of the Civil Code provides that disinheritance without a specification of the cause, or for a cause the truth of which is contradicted, is not proved, or which is not one of those set forth in this code, shall annul the institution of heirs in so far as it may prejudice the person disinherited, but the devices and legacies and other testamentary dispositions shall be valid to such extent as will not impair the legitim.